Welcome to Tax Break. My name is Jaclyn Roeing, and I am a counsel at Miller & Chevalier in Washington, D.C. I'm joined today by my colleague, Rob Kovacev, a member at Miller & Chevalier. Rob and I have spent much of our practices in the areas of tax controversy and litigation. Recently, there have been some major developments out of the U.S. Supreme Court that will impact how taxpayers and practitioners think about tax administration and challenges to Treasury and IRS regulations. Specifically, on June 28, 2024, the Supreme Court issued its opinion in Loper Bright Enterprises versus Raimondo and its companion case, Relentless, Inc. versus Department of Commerce. In these cases, a 6-justice majority held that the Chevron doctrine, which had been used to assess the validity of agency regulations, was overruled. Rob, why is Loper Bright important to the tax world?
Well, Loper Bright deals with challenges to the validity of regulations, and that's all regulations across the federal government, including Treasury regulations. And to understand Loper Bright's importance, you need to go back in time and look at a 1984 Supreme Court case called Chevron. And what Chevron stands for is that courts should defer to the interpretation of statutes that agencies use, so long as the statutory language is not unambiguous. So for years, the IRS, Treasury, as well as other federal agencies have relied on this Chevron deference to take very expansive interpretations of statutes to enhance and expand their power beyond what the four corners of the statute would seem to allow. Loper Bright takes that deference and basically throws it in the trash. So now, under the new standard, judges have to use their independent judgment based on the statutory language without deferring to any of the legal interpretations that Treasury or any other federal agency use.
Before we dive into Loper Bright more in detail and start unpacking what that means for the tax world and these points you've raised, I think it can be helpful to give our listeners a little bit of the historical background and a view of how courts have analyzed tax regulations over time. If we turn the clock back to 1944, that's when the Supreme Court articulated one of the earliest standards of respect for agency regulations in a case called Skidmore versus Swift & Co. Under Skidmore, agency regulations were given respect to the extent that they had power to persuade. And this was a somewhat more flexible standard that was determined based on a number of factors that courts looked at, such as the thoroughness of the agency's consideration, whether the agency's position was contemporaneous to the statute that it was interpreting, and the consistency of the position over time. 2 years later, in 1946, Congress enacted the Administrative Procedure Act, or the APA. The APA provides procedures for agency action and the basic contours of judicial review. The APA, however, was not regularly applied to Treasury and IRS regulations in the years after its enactment. There was a general idea in the tax community that tax administration should be exempt from the APA and general administrative law principles because of its complexity. This idea may be known to some of our listeners as tax exceptionalism. In 1979, the Supreme Court weighed in again on the review of Treasury regulations in a case called National Muffler Dealers Association, Inc. versus United States. The opinion didn't directly address whether or not the APA should apply to Treasury regulations, but it did provide factors for assessing the reasonableness of a Treasury regulation that generally aligned with the factors that had been articulated in Skidmore. The opinion in Chevron came out 5 years after National Muffler in 1984, and the opinion caused disagreement in the tax world for a number of years about which standard should apply when a court reviewed Treasury regulations. Should it be Chevron or should it be National Muffler? The Supreme Court resolved this question in 2011 in a case called Mayo Foundation for Medical Education and Research versus United States. And the Supreme Court affirmed there that Treasury regulations are subject to the APA and Chevron. So while we may have finally in 2011 gotten an answer on whether or not the APA and Chevron applied to Treasury regulations, at the same time, there was a growing discontent with the Chevron doctrine generally among practitioners and academics. And I think a notable fact to show how far Chevron had fallen out of favor by the 2010s is that the Supreme Court last cited to Chevron in one of its opinions in 2016. That now brings us to the present and Loper Bright and the challenge that it brought to Chevron. A few facts of the case I think are helpful before we turn to the analysis out of the Supreme Court. This case arose from challenges by commercial fishermen to a regulation promulgated by the National Marine Fisheries Service under the Magnuson-Stevens Act. The act authorizes the issuance of fishery management plans, which can require vessels to carry observers aboard them. Some provisions of the act authorize the agency to require vessel owners to pay for the observers in certain regions, such as the North Pacific, and at a relatively low cost to the fishermen. The agency issued regulations, however, that required industry-funded monitoring programs in New England fisheries, so entirely different location, and at a much higher cost. The judicial challenges came before the DC Circuit and the First Circuit, which both upheld the regulation before it finally was brought before the Supreme Court. So, Rob, you've mentioned that in Loper Bright, the majority overruled Chevron, and I was hoping you could walk us through some of the court's rationale to reach that conclusion.
Well, you have to remember that there's nothing in the Constitution that requires deference to executive agencies. There is nothing in any statute, with a couple of exceptions, I believe, where there's a statute that actually says that courts should defer to agency interpretations of statutory law. And if you look at the historical province of judges in our system, is that it's their responsibility and their duty to interpret statutes and apply the law, and that all litigants come before them and then receive the independent judgment of the court. And that's a cornerstone of the common law system. Chevron departed from that long-standing view, and ever since 1984, you've had judges who have, sometimes in their opinions, they'll acknowledge, I don't think that the government's interpretation is the best interpretation of the statute, but I can't say that the statute unambiguously says that they're wrong. Therefore, even though it's the worst of the two interpretations, I'm going to go with the government's interpretation because we have to defer to the agency's interpretations under Chevron. And I think what Loper Bright does, if you look at the opinion, is they go through the history of jurisprudence and how regulations have been reviewed going back to the founders in the days of the Constitution all the way through 1984. And they find that there has been a view of judges exercising independent judgment with due respect for the if there is any specific knowledge or institutional knowledge within the agency, but the law is the law. The statute says what it says, and you apply regular rules of statutory construction to interpret that statute. And if the regulation falls outside that interpretation, it's invalid, period. So Chevron departed from that, but there was no change in statutory law. There was no amendment to the Constitution that actually that was underpinning for that. It was just pulled out of thin air. And I think Loper Bright is a recognition that Chevron really was not based on any valid legal grounding.
What does Loper Bright mean for the tax world? What can we take from this opinion as we think about Treasury and the IRS and the regulations they issue and the kinds of challenges the taxpayers might want to bring to them?
Well, this goes back, Jaclyn, to one of the points that you made earlier. This fictive idea of tax exceptionalism. The notion that, well, yeah, other agencies have to abide by the Administrative Procedures Act, but Treasury and the IRS are far too important, so they can be above the law. And that view has been adhered to by Treasury and the IRS, and sadly unchallenged by the private bar for many, many years. In the past 10, 15 years, we have seen a shift in that, ever since the Mayo case, which the Supreme Court decided, which said that the APA does apply to Treasury regulations. Ever since then, the private bar has reasserted its role in our adversarial system of challenging regulations and has been increasingly successful. Now, that has been in the face of the Chevron doctrine's requirement that courts defer to agency interpretations. That deference is gone. So that opens up many Treasury regulations, makes them more susceptible to challenge, especially those that where the statute may be not unambiguous, but there are two competing interpretations, and the government's interpretation of the regulation is not the better one. In those cases where Chevron would have said Treasury wins, now the court must use its independent judgment, and the taxpayer has a much better shot at prevailing. And you will see this in various areas of tax law where there are regulations which have gone unquestioned for years, decades even, that are now going to be targeted because they are susceptible to challenge under the Loper Bright standard.
Let's pause for a moment on that last point, the Loper Bright standard. I'm curious for your thoughts as to what you think we should be looking at in terms of the standard of review for Treasury regulations following Loper Bright.
Well, one thing that Loper Bright says is that a court has to look at the delegation of power that Congress made to the federal agency. As we all know, Section 7805 has a very broad blanket. Treasury can do, can issue regulations to enforce the tax laws, something like that.
Yeah, if I may, that language is really going to be, I think, quite interesting. It's that Treasury has the power to prescribe all needful rules and regulations for the enforcement of the Internal Revenue Code. Seems pretty broad.
Well, it's so broad that it has no effect under Loper Bright. Because, that's, like saying, basically says Treasury can issue regulations. Well, of course they can. That's their job. But it doesn't say, and that means that they can issue whatever regulations they want, regardless of how the statute is interpreted. That's not what that says. Now, there are certain areas in the code where there are very specific delegations where your Congress says, the Secretary shall promulgate regulations to effect, some provisions or to prevent abuse in some specific provision. In those cases, I think courts will look more favorably on Treasury's interpretation. However, that does not apply across the board.
You raise an interesting question in terms of the type of deference that might be given to Treasury regulations. Do you think that we, with the reversal of Chevron, are now looking back towards something more akin to National Muffler and Skidmore for determining what kind of respect is owed to a regulation? Or do you think the analysis might look different?
Well, if you look back at Skidmore and National Muffler too, which is a very similar standard, even though they don't actually reference each other, the main thrust of it is that we will give deference to an agency's interpretation if we agree with it. So if a judge finds, the IRS's argument persuasive, but then the IRS, argument would prevail anyway because the judge finds it persuasive. So it really isn't deference at all. Now, I understand that there are some in government that have a slightly more muscular interpretation of Skidmore, where they say that because the IRS and Treasury have this unique knowledge of the tax code and how tax law works, that courts really should still defer to them out of respect for the superior tax knowledge contained by officials in Treasury and the IRS. Obviously, that's nonsense. Speaking as someone who was in government and is now in private practice, and speaking for all my friends and colleagues who were at Treasury, who were IRS, and were involved in promulgating regulations, they didn't get dumber the day that they left government service. So the notion that, and this is an area of positive law, this isn't an area of scientific expertise like, say, the FDA or NASA, where, rocket scientists at NASA probably are pretty smart and maybe smarter than other people outside. You look at Treasury and the IRS, and they're no smarter than us outside. So there's really no ground for deference at all.
So you've identified some of the key players in the tax world, right? We have Treasury, we have the IRS, and Congress also plays an important role in passing statutes that become the Internal Revenue Code. How do you think Congress and Treasury and the IRS will think about the process of issuing regulations under Loper Bright?
Well, one would hope that Congress would take a more precise approach in drafting tax statutes. Specifically, if there is a specific area where they say, we really need Treasury to provide regulations because we can't get to the granular detail in the statute that may be required to implement it, to enforce it, to administer it, they really should say so, and say so specifically, and not rely on the 7805 Treasury can implement regulations as needed. I think if Congress does that, that will give courts more guidance as to whether a statute, whether Congress intended the statute to give Treasury more latitude or not. And I think hopefully, and not just in the tax world, but generally when it comes to federal legislation that's implemented by agencies, one would hope that Congress will exercise its lawmaking authority more carefully in this area than it has in the past.
And I think those are all great points. I'm also curious to see the extent to which Treasury and the IRS might seek to engage with Congress, because certainly there are areas where Congress might have identified a desire for Treasury and the IRS to step in as something of the subject matter experts. But there might also be thoughts that Treasury and the IRS have in terms of administrability or the way that they are approaching their regulations and that process, and hoping to give that input to Congress to do its work in a more effective manner.
Right. Well, the Office of Tax Policy has historically taken a very interactive role with the tax writing committees on the Hill in trying to craft statutes. It's not unusual for the ideas for legislation, even language, to emanate from Treasury and then end up enacted by Congress, which is a healthy and probably necessary approach to developing tax law. That doesn't mean that Treasury is always right. And it certainly doesn't mean that Congress always accepts the recommendation. And I think more and more we're seeing that Congress goes its own way and doesn't solicit or doesn't give much weight to what Treasury does on certain tax issues. So it's going to be interesting to see as time goes on under Loper Bright, will that increase or decrease the amount of influence that Treasury has over the creation of legislation? It will certainly increase the Treasury's incentive to attempt to influence it. Time will tell whether that would be successful.
Yes, indeed. So that's something of a maybe more future look, right? Because by the time a taxpayer engages with a regulation, there's already a statute on the books. Hopefully, Treasury and the IRS have followed notice and comment procedures to issue that final regulation. So in terms of any changes Congress is making now to its process, we won't feel the effect of that for a number of years. What are the more immediate areas of the tax world that taxpayers and practitioners should be thinking about in terms of Loper Bright and its impact on the state of Treasury regulations?
Well, I think anyone with a pending controversy, whether it's in court or an exam, or that's anticipating a controversy, and there's a regulation involved that's adverse to the taxpayer's position, those taxpayers would be wise to look at that regulation in light of Loper Bright and seriously consider, in light of the statutory language, did Treasury pick the best interpretation, or did they just pick the one that expands the IRS's power the most? And if it's the latter, then the regulation may be susceptible to challenge. And regulations, there are so many areas where this could come to challenge. TCJA, Treasury has promulgated numerous regulations that have interpreted the provisions of that law. A lot of those are going to be susceptible to challenge. You look at research tax credits, foreign tax credits, transfer pricing. The Section 482 is just a couple of sentences long, and yet the regulations implementing it are this much. They're numerous and detailed, and it's going to be fascinating to see over the next several years how courts will interpret transfer pricing regulations, knowing that the statute gives very little guidance on exactly what the powers of the Treasury are.
I agree. It will be interesting to see. And I think 482 is one of those statutes, as you've mentioned, that has a express delegation of authority for Treasury to issue regulations. But again, when you've got the kind of imbalance in terms of volume you're talking about and the way that the regulations have developed over time, it does raise interesting questions about the kinds of challenges taxpayers could bring to those regulations under Loper Bright. I do think it's interesting to note, too, that you mentioned, Rob, look at current litigation, look at your current audits. And taxpayers shouldn't just be looking, though, at issues that are open, if you will. I'll note we're recording only about a month after Loper Bright was issued, and already courts such as the Western District of Tennessee and FedEx Corporation versus United States have ordered parties to provide briefing on the impact of Loper Bright. And the impact in that case is going to be on an opinion addressing motions for summary judgment over a year ago. And so that case has been ongoing. It wasn't fully wrapped up before the district court, and so the court still has jurisdiction. But I think it's really interesting to see that courts are saying, hey, even this opinion I issued over a year ago, let's take a second look at this and think about whether Loper Bright impacts the outcome. How does the landscape for taxpayer challenges to Treasury regulations change in light of Corner Post Inc. versus Board of Governors of the Federal Reserve System? That's another case regarding the APA and challenges to agency regulations that the Supreme Court issued just a couple of days after Loper Bright was issued.
Corner Post is a fascinating case that concerned procedural challenges to regulations under the Administrative Procedures Act, which is different than the Chevron Loper Bright substantive challenge to the regulations. But in Corner Post, the question was, what is the statute of limitations? When does that when does the cause of action accrue? There is a general 60-year statute of limitations for suits against the government and under the APA. And the question before the court in Corner Post was, does that start when the regulation is promulgated or when the party is injured by the effect of that regulation? And the court's answer was, it occurs when the taxpayer or the citizen is affected, when the injury occurs, not back when the regulation was enacted. And this is important because if the case had gone the other way, basically any regulation that was 6 years old or older at the time the taxpayer gets audited is, or as the audit is concluded, really, by the time they get a chance to go to litigation, there would be no opportunity to challenge any procedural flaws in how that regulation was issued. Now, because of Corner Post, any regulation years or decades ago that did not adhere to things like the notice and comment requirements in the APA, where the agency didn't engage in reasoned decision making under the State Farm Rule. All those are up for grabs, which is an important thing for taxpayers to keep in mind, because there may well be a regulation from the 60s or the 80s that no one's really thought about. But if you go back and look at the administrative record, at the time when no one really thought that the APA applied to Treasury regulations, was notice and comment actually followed? Were there comments, and were the comments seriously considered, or were they just ignored? And those questions are now, under Corner Post, live issues, even if litigation over the validity of that regulation takes place now, 20, 30, 40 years later. So it's very important to maintaining the integrity of the administrative process and protecting taxpayers from administrative overreach by Treasury.
It really seems like there have just so many doors have been opened to revisiting what it means for Treasury to promulgate regulations correctly under the APA, consistent with the congressional intent for the statute at issue. And Corner Post and Loper Bright are going to be raising a lot of questions for taxpayers. Thanks, Rob. I know Corner Post is a different opinion than we were initially focusing on here, but I think it's a really fascinating companion case to Loper Bright when you think about what the Supreme Court has done this term regarding the administrative state and the review of agency regulations. Rob, thank you for joining me today. This has been a really fascinating conversation about Loper Bright and what that case means for the future of the tax world.
Well, thank you, Jaclyn, and it's been great talking to you.
I'm going to say thank you as well to all of our listeners. We're glad that you were able to join us today. If you want to stay up to date on how Loper Bright is continuing to impact the tax world, we would encourage you to subscribe to Tax Break and also to check out our website, millerchevalier.com, where the tax group regularly shares articles on current developments in the world of tax. Thanks again for listening.
Produced by Heartcast Media.